A convicted killer now facing the ultimate punishment, death. Ryan Cole was found guilty of murdering a 15-year-old boy after breaking into the teen's Florida home. That young victim, prosecutors say, was trying to protect his little sister, shielding her from Cole's attack and paying the ultimate price with his life. Thank you for joining us. I'm Kennedi Walker, and I'll walk you through the details. You're watching Law and Crime.
Cases like this are why we have the death penalty in Florida.
33-year-old Ryan Cole was sentenced to death for the 2019 murder of 15-year-old Khyler Edman, a case prosecutors called one of the most disturbing they've ever seen.
There are few words to describe how horrific the crime was. No one should ever have to be a victim of a crime, but to be a young boy in the safety of his own home, he should never have been forced to know that kind of fear.
It was September of that year when investigators say Cole broke into the family's Port Charlotte home about an hour and a half south of Tampa. Inside, deputies say Khyler tried to protect his 5-year-old sister, confronting Cole before being fatally attacked.
There was blood everywhere, and there was things knocked over.
Khyler's mother took the stand, describing the moment she discovered her son's body.
I yelled, "Please help, somebody's killed my son."
Khyler's sister later told police that Cole pointed a gun at her brother. That's when the teen grabbed a kitchen knife to try to fight back. Deputies say the teen was found with multiple stab wounds to his torso. Cole also suffered stab wounds to his hands and side.
The defendant ended the life of a young boy and forever changed the lives of Khyler's family and friends.
Prosecutors argued the attack was brutal and intentional, pointing to Cole's violent history of 20 prior arrests and the condition of the crime scene.
Any loss of life is a tragedy, but it seems when you're dealing with a child, it kind of hits and touches everyone just a little bit differently.
A motive remains unclear. Investigators still don't know why Cole targeted that home. Cole pleaded not guilty and told investigators he was in a drug-induced blackout and woke up in the hospital with no memory of what happened. A psychiatrist diagnosed him with a psychotic disorder and noted a history of childhood trauma and substance abuse. After hearing emotional testimony from Khyler's family and reviewing evidence, a jury found him guilty of first-degree murder and armed burglary and recommended him for the death penalty. A judge agreed, formally sentencing Ryan Cole to death.
For the first-degree murder of Khyler Joseph Edman, the defendant is hereby sentenced to death.
While Cole now awaits execution, the Edman family continues to grieve, holding onto the memory of a young teen whose final act was one of selfless protection. And here to break down this story with me is criminal defense attorney Khyler Edman. Khyler, thank you so much for coming on today.
Thanks for having me, Kennedy.
So let's start with the sentence itself. Once a judge hands down the death penalty, what happens next? What's the process from here?
Well, once a judge hands down the death penalty, that's what's called a final judgment. And he is sentenced. Sometimes a judge will allow for the victim impact statement prior to handing down the final sentence. But then in the state of Florida, you have an automatic appeal process to the Florida Supreme Court. So most likely, this case will go to the Florida Supreme Court. And based on the transcripts, they will make a determination as to whether or not this was a fair and impartial jury, a fair trial to the defendant, and they will only look towards the trial issues only. This is not a do-over for the entire case. So they will only read the transcripts to see if there are any trial issues, which could have been objections that should have been sustained or overruled, or whether there was ineffective assistance of counsel. If they make that determination, then the death penalty will be overturned. But that is not an easy process because in the entire United States, it's usually 1 out of 8 cases are overturned. So this is going to be a very difficult process. And unless there was a clear abuse of judicial power or errors in the trial phase, this case will not be overturned.
Now, this case happened 6 years ago. How common is it for cases to take this long to reach sentencing?
It's very common when you're dealing with cases of murder or serial killers because you have to think about all of the evidence that must be reviewed during the discovery process. So typically you have the initial phase, which is the arraignment, the formal reading of the charges, and then you have the discovery phase, which is the exchange of evidence, witness depositions that must be scheduled and coordinated between the attorneys and the witness schedules. And then you have the trial prep leading up to the trial date. So this can take years depending on the schedules of the court, the schedules of opposing counsel, as well as the mindset of the defendant. And in this case, he was diagnosed with mental illnesses. So we don't even know whether or not he was incompetent to proceed. And if you are determined to be incompetent to proceed, then there's a process where the trial is at a stand up or held up until his competency is restored. So there's a lot of issues that come into play that can delay a case, typically when you're dealing with murder.
This is a Law and Crime legal alert. Did you know that children are being diagnosed with serious conditions like type 2 diabetes and non-alcoholic fatty liver disease? And research is potentially linking ultra-processed foods to these outcomes. Morgan & Morgan is stepping in to fight to hold food companies accountable. With decades of experience fighting large corporations, they're ready to stand up for families who deserve justice. If your child who's under 21 has been diagnosed with type 2 diabetes or fatty liver disease, visit www.forthepeople.com/food or scan the QR code on your screen to learn more. Now, regarding the death penalty, some people hear sentenced to death and assume execution is immediate. But in reality, how long do these cases tend to sit in the system?
Years. So the average in Florida is about 13 to 14 years on death row because you have to account for the appeals process. There are various factors that come into play. It's not automatic. And in Florida, the death penalty, you're basically on 24-hour lockdown. You eat the 3 standard times in the day, but it's basically a long process to make that determination as to whether or not there is any trial issues. So, with that being said, it could take a few years.
Now, Cole's team said that he was in a drug-induced blackout and had a psychotic disorder. Why do you think that didn't sway the jury?
Not at all, because if you look at the facts of the case, first and foremost, this was a home invasion. So when he entered this home and murdered this 15-year-old that was trying to protect his 5-year-old sister, that wasn't his first stop. He then entered another home. So he had the mental capacity to enter not one home, but 2 homes. And furthermore, he was in a right state of mind, so to speak, at the time of the incident. So oftentimes you just can't claim some mental psychosis, but throughout the phase of his home invasions, he knew exactly what he was doing. And I don't think that the jury brought it. On the defense stance, I mean, that's zealous advocacy, right? Whatever you believe can present reasonable doubt on the state's case in chief, you present that. But it wasn't strong enough to overcome the evidence that the state brought forth.
If a defendant claims that they don't remember the crime, how does that affect their legal responsibility? Obviously, it didn't work in this case, but in other cases.
Through my experience, I've tried over 100 trials, and oftentimes when I'm cross-examining the prosecution witnesses, typically when they default and say, I don't recall or I don't remember, but they remember everything else, it goes to their credibility, right? Because why don't you remember one portion that's very important, by the way, but you remember everything else? Well, the same applies to the defendant. If he claims he remembers everything else, but allegedly blacked out on how he committed the crime, the jury could look at that as if he's withholding some truth. He's withholding the evidence from the jury. And they are typically the ones that stand in judgment and will make that determination. So I don't believe that they believe that his temporary psychosis or his temporary blackout would have swayed them to believe that he was not guilty of this crime. Clearly, they found him guilty. And when you're dealing with a death penalty case, there's a 2-phase process. You have the death penalty phase, you have the guilt phase, and then you have whether or not he should be sentenced to death. And here in South Florida, or in the state of Florida rather, you need to have a unanimous vote as to whether or not the defendant is guilty. However, for the sentence of death, it no longer is unanimous. It is a vote. All you need is 8 people to agree that he should be sentenced to death. And the judge will make that final determination as to whether or not the aggravating factors supersede the mitigating factors and either sentence him a final judgment of death or a life sentence without the possibility of parole.
Well, let's talk about the trial strategy. The prosecution said that Khyler died protecting his sister. How much weight does that kind of narrative carry with the jury?
A lot, because you have to think about it. The judge sat through this entire trial. The jury heard all of the gruesome evidence. They had the ability to see the pictures of the 15-year-old victim who was a child in this case. A lot of that comes into play because unfortunately the victim died, but as a hero, right? He was protecting his sister from someone who decided to burglarize their home. We don't know whether or not who else was home at the time, but he tried to save his sister, who fortunately was not harmed during this incident. But a lot of that is taken into factor. Now, sympathy should not take a dominant role in the trial. And the jury instructions basically inform the jury that sympathy should not come into play. But it is considered, especially when they're weighing whether or not the defendant in this case should be sentenced to death or a life sentence without the possibility of parole.
Right, because I understand, jury instructions and they all have to follow those rules. But I'm just thinking about if there were other parents on that jury listening to that emotional testimony, like the mother describing the crime scene and walking in and seeing her son's body. Can we just talk about that, about how that affects sentencing decisions as well?
Well, the most important part, in my opinion, is jury selection, right? So, of course, the prosecutors, they would love to have parents on the jury panel because although the jury instructions state that sympathy should not come into play, it's really impossible to control that or to make sure that the jury is not considering that that could have been their son or that could have been their daughter, right? So it is the role of the defense attorney to make sure you don't have anyone who has children on the jury so that that won't come into play. So jury selection is imperative. So if you know that the victim in the case is a child, you may not want to have parents on your panel. But again, you're only allowed a certain amount of strikes for your jury panel. So you cannot strike all of the parents because just because they're a parent, as long as they can say that they will be fair and impartial, then that is not justification to strike a potential juror off of your panel simply because they are a parent. So you would hope that during that phase, the defense attorney looked into that, considered that, and struck as many parents off so that that won't be an issue during deliberations.
Do you think the defense could have done anything differently to avoid the death penalty here?
I think that they did as much as they could, right? So, although a defendant has the right to trial, doesn't mean they have a right to a not guilty verdict. As a former public defender, we try cases. Sometimes you just have to try the case for various reasons. There may not be a deal on the table, there may not be a plea offer extended by the prosecution. So, when that happens, you have to try the case. And there's been times that I tried cases because, again, the defendant is presumed innocent until proven guilty by the state of Florida, represented by the prosecution. So he is entitled to a jury trial by his peers. He is entitled to a fair and impartial jury. What the defendant is not entitled to is a not guilty verdict. So this is zealous advocacy. Sometimes you don't have a defense, but you just have to be the voice for the defendant in this case. And I think that that's what they did. They tried a case that had overwhelming evidence and they upheld the hands of justice, equal in the scales of justice, and provided legal representation to a defendant who's entitled to it by the Constitution.
Well, moving on to the criminal evidence. The suspect had stab wounds on his hands and side, according to police. Is that kind of physical evidence powerful in tying someone to a violent crime?
Indeed, it is. And the stab wounds were similar to the stab wounds that was on the victim. So I'm pretty sure that the prosecution made that connection that the victim fought for his life and also to protect his sister. And those stab wounds were similar. So I'm pretty sure that they were able to make that connection. And of course, the jury agreed. And he was found not too far from the crime scene after he did his second home invasion. So, all of this evidence again, the blood evidence, the stab wounds, being found with the defense wounds on both the victim as well as the defendant in this case, tied together that not only did he formulate this intent, he had the criminal mindset, mens rea, to commit this crime. And unfortunately, this 15-year-old Angel was murdered.
If the sister hadn't survived or given a statement, how might that have changed the prosecution's case?
Well, it again, it all depends on the evidence at hand because then you're dealing with um, two victims if he would have also killed the younger sibling as well. So you're dealing with more evidence. And I don't even think that they needed the testimony from the surviving witness because it was already overwhelming evidence in this case of a home invasion. There was already overwhelming evidence of DNA that was on his body as well. So even without a witness statement, I do believe the prosecution could have still proven their case beyond a reasonable doubt that a crime was committed and Ryan Cole committed that crime.
Well, regarding the law and the death penalty, Florida has been executing more people in recent years. Are we seeing a shift in how the state is handling capital punishment?
We definitely are seeing a shift. And this dates back to the horrific incident that happened here in Parkland, Florida, when you had the shooter kill 17 people at Marjorie Stoneman Douglas and injure 17 more. And he pretty much escaped the death penalty because of the votes. Usually it was prior to the law changing, it had to be a unanimous decision for not only the guilt phase, but the penalty phase. Unanimous 12 jurors agreeing that the defendant needed to be put to death. That was recently changed. Now it's 8-4. So this is why we're seeing an increase in death penalty cases because it's no longer unanimous. Less people can recommend. But again, ultimately, it goes to the judge. The judge will make the final judgment as to whether or not the aggravating factors overweigh or outweigh the mitigating factors and make that determination to agree with the death penalty or life without parole.
Well, what makes a case death penalty eligible to begin with? Is it just if they've been found guilty of first degree?
Not necessarily. It actually begins prior to that. So the prosecution must make that announcement as to whether or not this case will qualify as a death penalty case. So there has to be proper filings, timely filings, and oftentimes that is made in the very beginning. But sometimes the defendant is given the opportunity to take a plea to a life sentence to avoid the death penalty, to avoid the victims having to sit through trial and see and witness the gruesome photos and relive this horrific incident. So it's usually done in the beginning, but oftentimes the defendant may reject that offer and the death penalty remains on the table and they risk having that sentence after the guilt phase. So it's always done in the beginning so that the defendant in this case can make that proper decision as to whether or not he wishes to waive his right to a jury trial, accept the state's offer, or reject the state's offer and go to trial.
How often do juries in Florida actually recommend the death penalty today?
Well, it depends because at first they have to be qualified as jurors. So there's a phase where you're doing jury selection to make sure that that person, if the defendant is found guilty, will you be able to render a death penalty based on the law? So it all depends on the jurors. And that's usually a reason to strike. Oftentimes, jurors will not even sit on a case. They will state their religious beliefs. Some jurors don't believe that they should render a death penalty sentence. So the numbers all depend on whether or not the cases go all the way to the penalty phase with the juror if the defendant is found guilty and whether or not that juror was selected. So there's a lot of things that come into play.
For people watching who might be for or against the death penalty, what do you think that they should take away from this case in particular?
Well, of course, we would like everyone to serve their civic duty, but every jury trial is not for everyone. As I stated before, I've tried hundreds of cases, and when you're picking a jury, they know from the very beginning what type of cases will be, whether it will be civil or criminal. So the first thing is we want you to serve on the jury, but every jury is not for you. So we want you to be first and foremost honest. If this is not the case for you, you can let the attorneys know, this is not the case for me. Unfortunately, I may have some bias, but this is the only way this system works when we have citizens of the United States participating in their civic duty, serving on the jury.
Well, looking ahead, what happens to Cole now? Where does he go, and how is his life monitored while he awaits execution? But I know you said it's probably going to be years and years from now until that actually happens with the appeal process.
Cole is going to be on 24-hour lockdown, breakfast at 5, lunch at 10, dinner at 4. He's also starting the appeals process to the Florida Supreme Court, which is an automatic appeal process. So we don't know how long this will take, how long the transcripts will be. They must be reviewed to see if there's any trial issues or errors. So this could be years in the making, but typically on average, it's 13 to 14 years during the appellate process to make a determination as to whether or not that death penalty sentence and final judgment will stand.
Well, this is a case that we will be following closely. Casey, thank you so much for coming on today.
Thanks for having me, Kennedy.
Ryan Cole will now head to Florida's death row. There have been approximately 7 people put to death in Florida this year, with an 8th scheduled for later this month. For Law and Crime, I'm Kennedi Walker.